Hello, good evening and welcome to Spotlight. My name is Nuong Falong. You're watching MX24 Television, your home for fun, fearless and factual content. Now, I have a question for you this evening. Is legal education a privilege or a right? This is a very pertinent question that keeps emerging over the years as we continue to witness wranglings between law students, or should I say, people who want to become law students, and the Ghana Legal Council. Now, this question stays unanswered. We are going to be probing further today. Now, the Ghana Legal Council continues to wrangle with these aggrieved law students. This year, we know that Parliament passed a resolution directing the Minister of Justice and Attorney General and the General Legal Council to admit 499 embattled students who have been pushing for admission. They have come to be known as the 499. However, the excitement or the joy of these 499 students did not last long because the Attorney General, Godfred Yeboah-Dame, quickly responded to Parliament stating that Parliament cannot direct the General Legal Council on its admission processes by resolution. Interesting remarks there. Now, in a letter that was addressed to the Speaker of Parliament, Godfred Yeboah-Dame argued that Parliament cannot use a resolution to make such directions. And I'll just quote a little bit from that letter. He says, while recognizing the general legislative powers of Parliament in Ghana, except as have been circumscribed by the Constitution, I am constrained to advise that Parliament is devoid of power through the use of parliamentary resolutions to control the process of admission into the Ghana School of Law. Well, some members of Parliament have also quickly responded to this particular statement. But let's get into all of that shortly. We have the relevant stakeholders joining us here on Spotlight. Before I introduce them, let's take a quick break and come back to Spotlight. Stay with us.
Across Africa, nations are beginning to trade among themselves like never before, creating the largest continental market the world has ever seen. On the Single African Market Program, we will show you how products, services, capital and people will be crossing barriers as the continent and its citizens embrace a single market in a sustainable manner for growth and development to meet targeted UN development goals.
Congratulations, Your Excellency.
Get the latest update on all opportunities from the Continent's Trade House. Know the success stories and how challenges are being addressed. Africa is ready to trade among itself and the world, so are the people. The Single African Market is the voice of businesses that trumpets the vision of Africa everywhere, in association with the Government of Ghana, International Chamber of Commerce, Business for Peace Foundation, GIZ, UNECA, and UNDP.
The Single African Market, this Monday at 8 p.m. on MX24.
The Bible said that we are not of those who shrink back, but of those who believe to the salvation of the soul. You know, sometimes God wants to do things in circumstances and situations that when people see, they will acknowledge that this is not the effort of man, but this must be the finger of God. So to him, life meant Christ. Life meant living for Christ. Life meant serving Christ. Christ in you the hope of glory.
ICGC Evangel Temple presents The Kingdom Culture with Reverend Eric Ampofo on MX24. This and every Sunday at 3 p.m. Don't miss out.
Welcome back to Spotlight. Before we went on the break, I told you exactly what we are discussing. I also mentioned that we have the relevant stakeholders on this program with us. We have in studio, we have Hassan Asari. He's the president, National Association of Law Students. He's right here in studio with us. We also have joining us on Zoom shortly, Mahama Ayariga, Member of Parliament, Boko Central, the Honorable Mahama Ayariga. He should be joining shortly on Zoom. Also joining us on Zoom is Dr. Rashid Dramani. He's a parliamentary expert. There's also Daniel Saki. He's a law student. He's right with us on Zoom. He's already joined. We also expect Christian Malmhesi, who is also a private legal practitioner, to join on Zoom, and Regina Amega also going to join us on Zoom. We're also honored to have Professor Kweku Asari, popularly called Kweku Azar, joining us on Zoom there. Gentlemen, you're already on Zoom. Welcome to Spotlight. Good evening and thank you for your time.
Good evening.
Hassan.
Yes.
Welcome to Spotlight. We haven't had you here before.
Yes, that's true. Good evening. And
Good
evening
evening
to your viewers.
It's good to have you. Hopefully we can
Thank you.
get more of your time subsequently.
Okay.
Prof, welcome to Spotlight again, and thank you for joining us.
Thank you, Noam.
Also, Daniel Saki. Prof, today you are in good company with so many legal minds.
Well, that's good. It's always good, you know. Yeah. I believe in a knowledge economy, so I've always said that, look, let's educate everyone who wants to be educated.
What does knowledge economy mean?
Remove all the restrictions.
Right, right. I know you've been advocating for a long time about that. Looks like if we are lucky, we will see some changes related to that very soon in Parliament. We also have Dr. Rashid Dramani. He's joined. Hello, Doc. Good evening. Doc, can you hear me? Please unmute yourself if you can hear me. We can't get any feedback from you. Okay. Thank you so much for joining. I'm hoping that you can hear me. Dr. Rashid Dramani has joined us on phone. Okay, let's get right into it now. My producer is just going to quickly play one of the videos from Parliament, and then we can move into the discussion. Please just watch that.
But in other jurisdictions, students are able to go through with their tutors after writing your exam, and your tutor will happily take your script and tell you, Alexander, you didn't do well here, you got 2-1, you got 2-2, you could have done better. It's a taboo to ask for your scripts. That's not the kind of academia we want to have in Ghana. That is not. So, Mr. Speaker, just as politicians, when we get it wrong, they tell us. We are telling Ghana Law School that they continuously frustrating students. They are making the study of law unattractive. I know that for the post-call students, they have started lectures. They started last week. But for the professional law, they are starting next week. Ghana Law School General Legal Council must take the views of this parliament seriously by quickly taking steps to remedy the situation. This is Parliament, the voice of the people, and the people's representatives are saying that if you said it's 50%, all those who made the 50% and above, they are about 400 of them. It's not too late to admit them because they have passed. The problem is the type that we must confront head on. Mr. Speaker, I mean, it is said in Akan that if you give a child a load, telling him or her that, oh, when we get to the clerk at table's place, I'll offload, I'll relieve you. And then you get there and say, oh, let's just add a short distance, the child becomes frustrated. You have set your benchmark saying that pass mark is 50. People score more than 50. Now you are bringing other technicalities to justify why, even though you have gotten 58, you can still not go. Meaning, someone could have gotten 51, but because based on this explanation, he will be going and you have 60, and because of that explanation, you cannot go through. This is a very unfair system. And the least this house will do, in my view, is to interrogate this matter. Today, I'm told that this year alone, 260-something were called to the bar. This year alone. So, there again, there's been some progress. I think the issue before us today is not necessarily about how many people are being called to the bar. The issue is transparency and fairness in determining the rules of the game. When we were students, we were told that only 60 of you will go to the law school. So we knew. So it wasn't a question of whether or not you passed. The question of whether when they finally put the results together, you are among the first 40. So they will count 1, 2, 3, 4, up to 40, and then they will draw a line. And all of you will go as LLB students. You could get 70% and still not make it into the category of 40. And we understood because the rules were clear. You could get 80% and still not make it because the rules were clear. So for the law school to tell students that the pass mark is 50%, and then students get about 50%, then you come and tell them that, oh, there is a section that you must get about 15%, another section. I mean, that is clumsy. And the law pass mark as advertised by the law school before the exam was clear, 50%. In that advert, there was no such thing as you must get 25 or more here and 25 or more here. So can the law school, after the exam, introduce a variation to the rule? That is the issue we must deal with. And then the law school is a creation of Parliament. It's a legislative body. So can Parliament do? That's what I want us to focus on now. That no, Mr. Speaker, I want this House to resolve or to pass a resolution that the General Legal Council must respect its own rule that was set, and that's the 50% pass mark. And all the 490-something students.
That is the position of Parliament where this is concerned. Now we understand that the General Legal Council is committed to quality, of course, turning out quality lawyers. But in the process, can we stick to transparency and fairness? Is that happening presently in legal education? It doesn't seem like so where the stakeholders are concerned. So let me just take a few quotes from the Attorney General's letter in response to Parliament's resolution, which you just watched. Now, I'll read this again. While recognizing the general legislative powers of Parliament, except as have been circumscribed by the Constitution, I am constrained to advise that Parliament is devoid of power through the use of parliamentary resolutions to control the process of admission into the Ghana School of Law. Now, the mode of exercising legislative power enshrined in Article 106 of the Constitution does not admit of resolutions. The Attorney General also continued that it is instead the executive who can lawfully make such directions to him, and noted that the President is already taking some action on the matter. The action the President is taking exactly, we do not know yet, as he has not come out with a definite statement. Now, I will quote again from the same letter. In my respectful opinion, he says, this provision underscores the capacity of the executive, not the legislature, through the minister responsible for the General Legal Counsel, i.e. the Attorney General and the Minister of Justice, who direct and advise the Council on matters of national importance. I should also mention that some members of parliament have already responded to the letter from the Attorney General, and I'll just read from that also. This is from the office of the Member of Parliament, Honorable Roxton Dafiamapo, and in this letter he says, Sir, we write to request the Legislative Drafting Office to draft for subsequent submission to the Speaker a bill to amend the Legal Professions Act 1960 Act 32 to exclude the Chief Justice as well as other justices of the Supreme Court from General Legal Counsel, to redefine the functions of the GLC and to provide for reforms in legal education such that accredited faculties of law with the requisite facilities would be licensed to run professional law courses. So that's an interesting turn there, one that some people, of course, support. Let me just go to our guest. We have on the phone Professor Kwekwa Sari. Let me just go to him first. Prof, what is your initial position after listening to Parliament, listening to the response of the Attorney General, and also the letter coming from some members of Parliament?
Well, Nuan, thanks so much for having me. And it's interesting listening to all the stakeholders, Parliament, Attorney General, and so on. The first reaction is the problems are not new. These are not new problems. We did not wake up suddenly to find this problem, and then we are having to struggle to come out with a solution. These problems have existed since 2015. There has been several court actions and decisions rendered based on them. In fact, in 2017, we had the opportunity, we lobbied Parliament that LI 2235 was potentially very dangerous, so they must reject it, and that did not happen. We are dealing with an old problem. The second thing is that the Attorney General is right in saying that under the Legal Profession Act, the Attorney General has the power to direct the General Legal Counsel. And I've on several occasions called on the Attorney General to direct the General Legal Counsel to end the monopoly that it has created for the Ghana School of Law and to allow competition in the provision of legal education, because when you have competition, that's how you are going to ultimately increase quality, innovation, and lower costs. All of that have fallen on deaf ears. So at least I'm happy that the non-binding resolution passed by Parliament got the Attorney General to wake up and to tell us that it has the power that it has not been using, power that has been allowed to go dormant. So yes, Parliament, the resolution that it passed is non-binding. Nevertheless, non-binding resolutions are part of the repertoire that is available to legislative bodies. It allows legislative bodies to express an opinion on an administrative body's action, as here, for instance, all that Parliament was saying with that quote-unquote directive was that the General Legal Counsel is acting ultra vires because under the rules as we know them and as we've been made to understand, in fact, it was clearly stated last year by the Chief Justice that the passing mark is 50, And if you set that expectation, then there are all kinds of legal doctrines that stop you from changing that expectation in midstream. So Parliament was right in issuing that directive. That directive was not meant to bind the General Legal Council, but it was a signal to them that if they don't act lawfully, Parliament may intervene and even do more things like dissolve the General Legal Council. And by the way, like amend or perhaps replace the Legal Profession Act. The Legal Profession Act, after all, was enacted in 1960. So it's 61 years. If it was a natural person, it would have been retired by now. So it is time to retire the Legal Profession Act, 1960, and enact a new Legal Profession Act 2021 or 2022 that takes into account modern development. That takes into account that we have about 11 universities offering the LLB compared to 1960 when University of Ghana was the only university offering the LLB program. The other thing that most people forget is that the Ghana School of Law is not a university.
Right.
It is an institution created for the narrow purpose of offering practical training. If I'm allowed to quote the words of Lord Denning and the International Advisory Committee that recommended the Ghana School of Law, it is almost like a finishing school where everyone who has an LLB is supposed to go not to take exams, but basically to learn etiquette, drafting, bookkeeping, and so on. They were never supposed to be teaching law, like family law, like civil procedure, like evidence. Those properly belong to the universities. It is unthinkable to me that a student will have an LLB and will not have taken evidence or civil procedure or criminal procedure or family law or any of those courses that they have reserved for a school that is not a university. So there's a lot that is wrong with the current setup, and I am pleased that at least I've seen some private member bills that intend to move us forward by, one, breaking the monopoly of the Ghana School of Law, two, making the LLB count. That is, anyone who has an LLB is given an opportunity to sit for the licensing exam. That's how we tell quality, because if you are not well trained by your school, you will not be able to pass the licensing exam. If at the end of the year, people look at the statistics and students from University X, 70% of them passed, and students from University Y, 40% of them passed, well, there will be a bigger demand for University X. That is how you introduce quality and innovation into education, not by a monopoly. Monopolies, by definition, destroy value because they don't care about quality, they don't care about innovation, they don't care about cost control, because they know no matter what they do, people are going to come. So people often say that quality, 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 and so let's go to the Ghana School of Law. I'm inviting the media one day to go to the Ghana School of Law to videotape how they train the students. You have about 200 students packed in one room, and the students are supposed to go for lectures for 12 hours. No university will institute this type of arrangement because it's counterproductive. It is not the way people study. Nobody is able to absorb materials beyond 4, maybe 6 hours maximum.
Prof,
so
these see, without the intervention of the executive or even Parliament, is the Attorney General and the GLC, are they unable to make these changes that people are calling for?
They can make those changes. In fact, if they made these changes, then we will all be happy, because that's what we've been asking. I've asked the Attorney General to make those changes. I've written to the Ghana Legal Council many times and told them to get out of the business of education and then focus on the business of regulating. They should regulate the schools. They should have no interest whether the courses are offered at University of Ghana or University of Cape Coast or even Ghana School of Law. They should concentrate on accrediting universities, inspecting facilities to ensure that the facilities are top-notch, and then through the independent examination board or a board of examiners, provide a biannual licensing examination where students apply, they take the exams, and when they pass, then basically they get enrolled.
Thank you, Prof.
Universities today are able to offer all kinds of clinics and practice courses and advocacy skills that in the 60s we did not think they could do. That's why we created the Ghana School of Law. That argument is outmoded. Modern law faculties can provide everything that the Ghana School of Law was set up to provide.
Right. Thank you so much, Prof. That's a mouthful. Let me just bring in Dr. Rashid Dramani to ask him the parliamentary angle. Doc, can you hear me? Great. So I just want to find out from you quickly, is there any limit to how far Parliament's mandate goes in terms of giving directives to bodies which are constituted through an act of Parliament?
The short answer is no. Even if they were not constituted by an act of Parliament. I think in a republic, there is no one who is not subject to parliamentary oversight. And when we talk about parliamentary oversight, sometimes people just think that oversight is about looking at whether monies are spent properly or not and so on. There is also what we call administrative oversight. I mean, Parliament, as the body that represents all of us in this republic, has the right to get involved and look at matters that are administrative in nature, that are of public interest. And I think in this particular instance, that is what Parliament has done. And
Dr. Rashid, what then do you think of the response from the Attorney General?
Well, you see, my sister, when I read the response from the Attorney General, I'm not a lawyer. I hear a lot of, kind of issues that are very convoluted. And in this country, that is a very smart way that we have used over the years, to put our country where it is currently. In matters of education, I believe as much as possible, if we can find a way to leave the politicians out of it, that will serve this country much, much better, because there's too much political interference when it comes to educational matters. And here I'm opening the door very wide to go beyond what is currently happening with the School of Law. I've heard the law professor speak eloquently about this. The fact that the General Legal Council should, take itself out of the business that it is in right now, and then perhaps maybe focus on what is important in the legal profession.
Thank you, Doctor.
Countries are going to the moon today, and here we are. We are sitting here and arguing about
breaking the monopoly.
Our citizens are running to the Gambia, to Botswana, to other
Rwanda,
places to go and learn law, and come back to this country and come and practice. And we are here just arguing and arguing and arguing and drawing on the Constitution, drawing on politics. And at the end of the day, I think it's the ordinary citizen that suffers. And that is why Parliament has a very important role in this. And I support particularly the honourable member who is initiating a private member's bill. I think that's a step in the right direction.
Great. Thank you so much, Dr. Dramani. Let me come back into the studio where we have Hassan Asari. Hassan, listening to all this, I know you're one of the people who are happy about some of these developments. But how does it feel when the Attorney General comes back with such a response?
It's actually depressing, especially when we heard Parliament speak and we were sort of happy that there is hope, finally, because we had already...
I'm sure some of the 499 were getting ready to go to school.
In fact, they are ready, actually. So they have hopes that this is going to work this time, because we had actually petitioned almost everybody. And the only response we had received was from the presidency, that they acknowledged receipt of it. Then when we went to present the second petition, after demonstration, the deputy chief of staff actually said the president has directed that the earlier petition be sent to the Attorney General. Now, we didn't know what was going on, but the shock came in after the second petition and with that statement that the president said there was no space. So you recount and then you don't know where exactly the position of this whole thing is going to. At one point, it's referred to the AG to take care of. The next moment, we don't have space. Is it the AG advising the president? We don't know. The GLC will not speak on the matter. So we were a bit in limbo until Parliament spoke. Then we knew that, okay, at least we've been heard. Because most often than not, there is that perception of they have failed and they want something. But in this case, they had passed and just wanted an enforcement of the same rule.
Of their rights.
Let me touch something that the Attorney General actually said about the 50% mark issue. Now, I feel, in my opinion, it's a red herring just to push the focus away. Because by their own actions, those in there now, the minimum that they took is 50. So it's fine. That issue for me is settled. The problem has to do with the rule that has changed. That came in later, which we weren't privy to. Now, if you look at the rule that relates to promissory estoppel, when you rely on something to your detriment, you cannot enforce it. Besides that, you cannot apply laws retrospectively. So we thought that all these things actually were not in the interest of Article 23, which talks about fairness, which talks about not being arbitrary, and other provisions in there that we thought was affecting us. So all we're asking for was for them to ensure that we go to school as per their own rule. So I think that's what we're... So to hear him say this, now we've gone back to our limbo mood. Are we going or we are not going? Because he said, the president said he should intervene in the matter. Now, intervene how? Are you going to intervene by getting us to go to school? Or you are just going to find a solution for the future? So we are still not there yet. But we wish that a communique will come quick to actually resolve this. And actually, I chanced upon the private member bill that Prof was referring to. I think it's fantastic. And it's something that will bring a closure to all these issues.
But you know, this is a real problem, the question of space not being there. It's something that's been spoken about. There aren't enough physical resources to admit the 499. Where should they be put?
It's a bit sad, but I'll take you through two sides. For example, in this 21st century, we are still talking about brick and mortar. Can't we go virtual? Because when COVID was up, I think they went virtual. So it's a provision that can actually be looked at. That's one. Two, if you're talking of space, I can tell you on authority, I can find space for them in Accra. There are so many spaces in Accra just for 500 people. So I think it's an excuse of some sort that actually does not sit well with some of us. We think space for 500 should not be a problem. In fact, until in last year, they actually said they were going to expand one. They were going to look at the Law Village. You've been there recently. You see that there's just a chip of sand or something in there. Nothing has happened. If you go to University of Ghana, you go to UPS, you go to UCC, you go to UDS, you can find space somewhere. I mean, just 500 students. I don't think it's much of a problem. So that excuse actually does not wash.
Let me go to Regina. Regina is on Zoom. Can you hear me? Regina, oh, thank you so much. I understand you're joining us on phone.
Yes, I am.
Right. Now, in 2019, you were part of the students who protested over the failure of 1,500 students. Now you've been called to the bar. Would you say the system has gotten better as you continue to push?
Yes. I'll say this on authority that at every point in time, since 2016 down the line, there has been one form of protest or the other. Some of the protests, for instance, the 2017 and 2018 protests, were at the Ghana School of Law level, where they recorded massive failures during the final examination, to the extent that at a point, only 61 people were eligible to be called to the bar. So the issue is that it's not even just the entry, it's also at the exit. But 2019 was the defining moment for the students, for the LLB students. That is when the realization hit everybody that, look, until we speak about this issue, it's not going to stop. You realize that over the years, law school, medical school, there has always been this restriction with regards to entry. For medical school, you realize that they've quickly modernized and then have made it accessible. We have the KNUST, we have University of Ghana, we have UDS, we have UCC. And these are all run on the various university campuses. It's not the Ghana Medical Council that runs them. So now you come to Ghana School of Law. Every year, we have this agitation. For 2019, there was agitation. 2020, because people would say it's the electioneering year or the effect of the demonstration, we had 1,045 students being admitted. So what changed? What changed that now 1,289 students have passed? They've met the 60% pass mark, but the rules have changed. How is that possible? So then you realize that we take 2 steps forward and 1 step back. We are not moving forward. But what I can assure you is that the change is going to happen. It's bound to happen. You cannot suppress change for so long. So now, if you see what the response the AG gave to Parliament, and then the private members bill, or the private members amendment bill that has come out, you realize that now it's a power play. The AG is telling Parliament that you don't have the right to direct me, and the Parliament is saying that, okay, I'm going to do what I have the power to do, which is amend the bill. And that bill can even dissolve the GOC and reconstitute it. So you see that when people have been agitating, when people have been asking for change for so long, and it's within your remit to make those necessary changes, and you refuse to do that, this is what happens. The whole institution can crumble and then be reconstituted. So it is sad that we have to come to this point. But then again, it is good because it is progressive. We can't, as Prof said, we can't continue to have a monopoly over legal education, such that we have only one institution running professional legal education in this country. It must change. We must get to the point that people can sit back and plan their life. Like, okay, I'm going to go to law school. I'm going to start at the LLB. I know that when I'm done, I'll take the licensing exams, and then I can be called to the bar. There is progress. There is a well-defined path. But now people finish LLB, and it's a game of chance. It's a game of fate. Am I going to make the entrance exams? If I make the entrance exams on the first count, when I enter the Ghana School of Law, am I going to progress from part 1 to part 2 without being repeated? So these are the issues. For instance, if you go to the Ghana School of Law now, about 500 students have been repeated just because they failed 3 papers out of 6. So you ask yourself, if you are keeping 500 students in the system and not allowing 499 to enter the school, clearly you are just managing numbers. So what is stopping you from repealing that repeat policy? Allow students to move on, so that if the person moves on to part 2 and rewrites the 3 papers in the course of their study and passes, the person is called to the bar. Why do you still keep that person in part 1 to rewrite all 6 papers, thereby denying another chunk of people from even entering the Ghana School of Law? So we've created a problem for ourselves. The Ghana School of Law, the General Legal Council, have created their own problem. You've put in place a repeat policy, which is clearly not serving your interest, because the difference between a referred student and a repeat student is just 1 paper. So someone fails 2 papers, is able to move to part 2. Someone fails 3 papers, and the person repeats. But the person who fails 2 papers, moves on to part 2, is able to rewrite those 2 papers, passes, writes the part 2 papers, and it falls to the bar. So clearly, you can see that the repeat policy is not working. The repeat policy is causing the backlog. This backlog is artificially created. It does not need to be there in the first place. So the amendment should go to the root of it, even how the Ghana School of Law is even administered. Like the administration needs an over. Students today have to go to the notice board to go and check their review. Notice board really, they can be student portals and all. What's happening? So as Prof said, when there's competition, universities will offer the best services, the best professional legal education anybody could ever have. And then the quality will speak for itself. But insisting to have just one Ghana School of Law, keeping and promoting this monopoly would not inure anyone's benefit. So let's be progressive. Let's open up the system. And again, we need the lawyers. It's not as if we have too many lawyers. We do not have enough lawyers. We need the space. If UDA should start offering law now, we'll be dealing with the issue of the limited number of lawyers in the northern sector. So we need a lot of lawyers in the system. Look at legal aid. The few lawyers that are overburdened. We need a lawyer. The AG's office doesn't need lawyers. Why should we be allowing the police prosecute case when we can get law students to actually do that, or lawyers to do that? But then we are keeping a lid on opening the access, and then every time we are complaining that we are not getting enough lawyers, people are not getting access to justice, we have the solution, but we refuse to implement it.
Right.
So, none.
We know some of your colleagues have taken a step forward to sue the GLC. Do you think they stand a chance in this suit?
Oh, they do. They really do. Because, you see, you would get the judgment. And the case, in 2019, some of our colleagues actually also went to court. They got the judgment in favor of them. But then the GLC staged the execution, and they started an appeal process. And till date, they've still not, they've just held up the execution, and they're not proceeding with the appeal. Even though there are countless reminders by the student's lawyer to continue the appeal, they will just frustrate your system. So now it's boiled down to not just a legal solution, but then a political solution. Who has the stronger power? Is it going to be the court? Is it going to be the president? Is it going to be parliament? So as I said in the beginning, it's a power play now, because for over the years, 2019, the students got a judgment in their favor. Prof has gone to court countless times, but we are not seeing the way forward. The president or the executive is not who has the power to the executive to do the right thing. It's not doing it. Let's see what Parliament is going to do now. Parliament has received petitions upon petitions for more than 4 years running. So now they've taken a bold step to amend the act. Let's see whose power will reign now, because ultimately the power lies with Parliament if it's about amending the rules. So if the bill says we have the power and we are going to do what we want, and Parliament says, I gave you the power and I'm going to take it back, then at the end of the day, the one with the bigger power is going to win. Because if we are not ready to change, then the court is not giving that to us, the executive is not doing that to us, then by all means, Parliament should do what it has the power to do.
Thank you so much, Regina. Regina is a legal practitioner. She's also one of the students who went on a protest last year. Let me just go back to the line where we have Daniel Saki. He's also one of the 499. Hello, Daniel.
Good evening.
Good evening. Can you hear me?
Yeah, I can hear you loud and clear.
Fantastic. So what's the way forward for the 499 presently?
Okay, so the 499, like you all know, we started with petitions. We had a press conference. We spoke to the world. The world understood our plight. Parliament came out. Parliament unanimously proved that they actually realized that there is a problem with legal education in Ghana. We demonstrated. We used all lawful means, and now we are in court. We were in court on Friday, and the case was adjourned to 9th November. We'll go to court. We will use all legal means to make sure that we have justice.
You've seen that the General Legal Counsel has quite some amount of power. What do you suggest should be done to regulate this power that the council enjoys?
I want to say thank you to Professor Kweku Azan. I think there are a lot of solutions that were proffered, a lot of solutions that were prescribed by the learned professor. And if we can go back to the table, there are a lot. I would not be in a position to just come and re-emphasize the whole thing. But if Ghana is a listening country, I think we have to make good use of some national assets like the learned professor. And I will say that already we have faculties. If the faculties can teach us substantive law, what prevents them from teaching us procedural law? So if we are saying that, okay, if you will not even give the accreditation to all faculties, look for some selected ones that you think you can probably regulate and regulate well, and give them the opportunity to also train law students. As a matter of fact, there are some faculties that can even train better lawyers than what, with all due respect, what GSL is doing right now. So if you claim you don't have facilities, you don't have space, you don't have resources, and everybody realizes that there is a problem, let's rather go back to the drawing table and tackle the problem than trying to suppress admission and putting every innocent person who wants to become a lawyer into some kind of frustration. So to me, I think a lot of solutions have been proposed, and we have to just go back to the table and begin to roll them out.
No, if the Attorney General fails to act, and we know the private members bill has been raised, but this takes quite a process, what happens in the meantime to the 499?
It is quite unfortunate that innocent people who paid so much to attain or to obtain an LLB certificate were able to write an entrance exams and pass, are being put through such a very traumatic and frustrated experience. It is it's quite unfortunate. Our parents, sometimes parents will call you and they will be crying on the phone because they know the kind of effort, the kind of resources they put in the education of their children. It is very, very traumatizing. Look at it. A lady called me last week. She said this is the 8th time. She's been writing it since 2012. She's been writing these particular exams. It is only this year that she was able to make the so-called pass mark. What happens to the 499? Provided we are in court, I will not preempt the court. But like I said earlier, we are going to use all legal means to make sure justice is served and the 499 are admitted. But like it stands now, there is no sign and there is no positive sign that the 499 are going to be admitted. We are relying on the court, and we know that the court is going to give us justice.
Thank you so much. That's one of the aggrieved students there giving us his submission. Let me go back to Zoom, where we've been joined by legal practitioner Malm Hesse. Hello, Malm. Okay, I'm trying to... Hello, I can barely hear you. Okay, I think we're having issues with your line there. I tried to connect with you earlier. If you can, please come back to the line. My producer will keep trying to get a more stable connection. All right, let me come back to the studio here. What do you think can be done to compel the GLC to accept these students?
That is quite an interesting question. And I heard you pose same to him.
Because the Attorney General has given, this response. It doesn't seem like it's difficult to read him, whether he's going to proceed with, the requirements from Parliament or what everyone else is agitating for. What if the President doesn't come back and tell him the same thing? What happens?
At the moment, since we are in court, I think we'll go by the court.
Okay.
I think the first interview I granted, I made this categorical statement. I think the General Legal Counsel needs a total overhaul. We need to change the system or the composition itself. I'll tell you what. When Regina was talking, she said Prof actually wants some cases in court. One is the 2017 one, which actually said the exam and the interview were unconstitutional. In 2020, the case she's talking about, the Ganaku case, they actually said the undertaking, before you write the exam, you sign that when you fail, you will not question the results. There is no marking scheme that we've ever seen. In fact, the court ordered for a remarking. I tell you what, we're almost 1 year through, nothing has happened. Now, I compare that to the Rastafarian issue at Achimota. That was an educational institution which was instructed by the court to admit the boy immediately, and it was done. I see some kind of conflict of interest here. The CJ sits as an administrator or as a chairman of the GLC. Now you have, for lack of a better description, his subordinate, the High Court judge, instructing him to change or vary a decision he has taken. That will be quite difficult. And I'm sure that is what is giving them that power to actually behave the way they are behaving. I think if the composition is looked at, and indeed, I looked at some of the provisions in the Act 32. Faculties are, under the document, are encouraged, or the GLC is encouraged to allow the faculties to run it. Now, that even answers your problem of space. If we allow these same faculties to run it, and we have the GLC sitting as an examining body, like WAEC, I'm sure this problem will be solved. Indeed, you cannot tell all the JSS in this Ghana to be going to Infantipim school. It will crash it. We should allow other schools to come in, to come and help. If you don't have the capacity, you see, it's a very simple problem that, in my opinion, can be solved. But whatever interest people have and are pulling the strings, making it so difficult for innocent students who actually pass exams not to proceed, it's a bit depressing.
Very depressing, I'm sure. That's Hassan Asari. He's president of the National Association of Law Students. We've been joined again by Ma'am Hesse. Let me just quickly rope him into the conversation. We've been having issues with his line there. Mr. Hesse, thank you so much for allowing yourself to come back. Please unmute your line. Okay, now we know the Attorney General has written back to Parliament saying Parliament does not have the powers to direct the GLC to admit anyone. Is this your position as well?
Well, it has been my position. Before I apologize, I keep having a lot of calls and all that. But, I mean, it was obvious that Parliament never had that power so-called to give direct to a constitutionally mandated authority on what it ought to do and what it ought not to do. I mean, Parliament as a creation by itself, stemming from Article 93 all the way to 123, and particularly where it wields its power the most, Article 106, has all the power of legislative body. And where matters are of national concern, it can direct the minister to summon particularly the director of legal education to appear before it to answer questions of national interest. Beyond it, Parliament cannot direct it. Aside that, too, Parliament, just as we all know, could move in the lines of amendments of the Profession Act to see how reforms could take in to shape up legal education to respond to growing challenges and modernity. Beyond that, this basically is what Parliament is bound by.
Ma'am, did you encounter any of these issues when you were writing to get into the school?
I mean, interestingly, our time, the minimum was 250, the whole Ghana. I mean, times have changed. Yeah, we were about the last people to be doing 250, the whole Ghana. But times has changed, and now the numbers keep increasing, and law school will never do 250 the whole Ghana, because definitely. So I mean, interestingly, just as I'm saying, as times changes, there'll definitely be call for changes, reforms. But you know, you hear some of the kind of articulations and views proffered.
Okay.
Some of the views proffered, and some of the ideas are very welcoming. Others who are very radical. And for me, I insist on stakeholder engagement and dialogue in order to see how some of these reforms will take shape. I've heard some views that the General Legal Council will be dissolved because you have some judges sitting on the council. You also have the Chief Justice sitting there. The Chief Justice too should be taken off because it is an extension of the judiciary and all of that. But, you know, so such ideas are very radical and...
Ma'am, there's also been suggestions to retire the 1960 Legal Professions Act. Is this something that you support?
Oh, I mean, like I said, I mean, you go to England, there are acts which dates back to 1920s, 1910, which are still relevant.
I see. Okay.
Yes, it basically has to do with the fact that where certain sections are not yielding to, or I mean, they are not sorting out to these problems.
Do you think it should be modified,
sections
though?
are not adhering to? Oh.
Okay, Christian, I'm having issues with your line there, so I'm just going to move on to Prof. We'll try to
Sorry,
get.
I have a lot of meetings scheduled for me, so
Okay.
The meeting.
No problem. That's okay. We understand. Thank you so much, though, for your contribution. We understand your angle there. Christian is not on the radical train, although he agrees there should be some modifications. Let me go back to Professor Kwekwa Asari. And Prof, quickly, we know that some of these 499 students have sued the GLC. What if there's a likely ruling in their favor? Will those who are not part of the suit be exempt, or will this only apply to those who are part of the suit?
No, it will apply to everyone because they are in the same situation. Clearly, that would be resolved in their favor. I mean, it is very similar to my case in 2017. When the rule is there, you cannot just bury the rule because you have the power. You can't impose fiat on people. That is not done in any country that values the rule of law. But more important, you see, one of the things that we don't look at seriously is the Constitution itself. Because if you go back to 1992 and 91, when we were framing the current Constitution, monopoly of education was a big issue. And they resolved that in Article 25.2. If you read Article 25.2, it basically says, every person shall have the right at his own expense to establish and maintain a private school or schools at all levels and of such categories and in accordance with such conditions as may be provided by law. This is basically saying that you cannot have the government alone taking control of some aspect of education and saying it's not going to allow private participation. The Constitution itself forbids that. So for me, my starting point in any of this is, if you have a council that regulates the legal profession and they cannot read Article 25.2 and understand that the monopoly that they are running is counter to the Constitution, then we have a problem. And you can see that problem manifesting in many of the things that they do. So in 2017, the imposition of the exam and interview, the Supreme Court said it was unconstitutional. We've talked about Prince's case in 2019, where they asked students to make an undertaking that they will not look at their scripts. No person who is a serious educator would give this undertaking. It is clear to me that the General Legal Council, as currently constituted, the work that we've given them is way beyond their means. So we need to go back and say, look, we are way past 1960. In 2021, what is the best structure for regulating the legal profession? Let's put people there who would obey the law, who would act constitutionally, who would follow administrative processes, and who understand the importance of notice, hearing, and due process.
Right.
That is what we need.
Hassan seems
if we
to
don't
be...
solve that, I'll tell you my fear. My fear is that the 499 students are sent to the school, and some petty person or vindictive person starts victimizing them. You know, I worry about that. I worry about that. I'll be honest with you. I worry about that.
Hassan seems to be very excited about your submissions. He's smiling over here. But let me just ask you the last question before we go. Now, we know that the court hierarchy in Ghana is such that we have the lower courts following the directives of the higher court. In this case, we've seen that the High Court answers to the Supreme Court. Can the High Court make a ruling that affects the General Legal Council, looking at the composition of the GLC?
Oh yeah, if you have a bold judge. In Kenya used to have this entrance exam. It took a high court judge to declare it unconstitutional, so they stopped this entrance exam in Kenya long ago in 2017. So it depends. Remember, even my Supreme Court, the GLC membership involves the 4 most senior members of the Supreme Court. But a panel of the Supreme Court decided that their actions were unconstitutional. And remember again that in the Prince Jinaku case, a high court judge declared that the GLC's, their warrant that students signed undertaking was arbitrary and unlawful. So
okay,
yes,
so
a high court judge, who in his judge, can basically say, yeah, I've looked at the facts, and based on the facts, you've acted unlawfully. As I'm sure the judge will do in this case.
Thank you so much, Professor Kweku Asari. He's a private legal practitioner. Thank you for your submissions. We're just about closing, but Hassan, sum it up for us. What's next for the 499?
I think we are in court. We are hoping that the back and forth between the AG and Parliament would be resolved in our favor, regardless of whatever their differences are. You see, all we need to do is to resolve the problem such that the students who are qualified as per the rule that was communicated on the 14th of May is enforced. Beyond that, we feel in order to cut off the issue of every time we don't have space, they can allow the faculties to run the PLC. Now, let me just take you through a short trail. Before you come into the law school, there is an entrance exam, which in my opinion, and from the look of things, all intents and purposes, does not look credible. Because if I have to sign an undertaking to say I won't question it, when you write...
But the students agree to sign this.
You are forced. The word duress. You see, it's part of the requirement. If you don't sign it, you can't move to the next stage. It's on a laptop. It's not a paper thing.
Okay.
It's actually in a system. And if you don't cross it, you don't move to... Without it, you can't even qualify to write the exams. So you're actually forced to sign it. Now, as much as we don't want it, and we've gone to court and even we won the issue, we are still being made to sign it. So that is where the issue of credibility comes. Because if for any reason an examiner writes 37 instead of 73, I cannot question when I know I've done very well. So they use it to actually limit the intake, as if it's not enough. When you go abroad, Gambia, wherever, and you pay X amount, finish school, and you come, they charge you £6,000 for you to do your post-call. Whilst you are inside, if you fail 3 papers out of 10, you repeat all of the 10. Which, in my opinion, it actually limits the space, and we need to find a way to resolve this as soon as possible.
Thank you so much. That's Hassan Asari. He's president of the National Association of Law Students. My name is Nwang Falong. To you at home, we're grateful that you stayed with us through this 1 hour. Unfortunately, we couldn't open the lines today. We're pressed for time. But please continue the conversation at MX24GH on social media. We'll be following this case closely and giving you updates on the news and other programs here on MX24 television. On behalf of the entire production team here at MX24, we're grateful for your time. Good evening.